Bom dia. É prazer estar aqui. Now I've exhausted all of my Portuguese, and that took me about 2.5 hours to learn, and I'm being serious about that. Oh, can we get the next presentation up there? Bingo. All right, so I also want to thank IBRAC for inviting me to participate here today. This is a very interesting conference, and I have to say it's the first time I've been in Sao Paulo or Brazil, and I want to move here, honestly, which my wife may take as not good news, but I think I can win her over. So anyway, I know we need to stay on schedule, and why don't we do that? So I'm going to talk about, as Brent said, from the perspective of U.S. private defendants in cartel class actions, how does the efforts of plaintiffs to obtain the leniency documents, that is, the documents that the leniency applicants have given to the Department of Justice as part of that process, how does that play out from our perspective? And I'm going to talk mostly about the U.S. side of this, what happens in the U.S., but I'm going to also touch on the EU side. And that's because the U.S. and the EU have come out in somewhat different places in addressing what I see as the fundamental issue here. How does a regime balance these two conflicting considerations, encouraging leniency applications and protecting the integrity of the Department of Justice or other prosecuting authorities' investigation versus enabling private plaintiffs who claim to have been harmed by cartel activity to recover damages for their alleged harm? And I would suggest that examining the way this works in the US and the way it works in the EU may provide models for other jurisdictions, including Brazil, to look at and decide, well, we like this piece of that model, we don't like the way that works, as they are thinking through these issues for their own jurisdictions. So, with that, we're going to start with the United States. And you heard from Brent about U.S. Department of Justice policy, which is to very aggressively protect the integrity of leniency documents. Now let's turn to what happens in the private litigation. So what are we talking about? There's a Department of Justice criminal investigation to cartel activity. There is a leniency applicant, and then once the existence of the investigation becomes public, the private class action plaintiffs' lawyers, whatever they're doing, they stop what they're doing, they rush to their computers, and they start working on complaints and get them filed as quickly as possible. We end up with multiple complaints, often in multiple jurisdictions, which eventually get consolidated into one consolidated class action complaint in a multi-district litigation proceeding in one court. Now, turning to the real question, what are the rights of the plaintiffs in those cases to get access to leniency documents? To answer that question, we look to what are the rights of parties in private litigation in federal court to get access to discovery, including documents, because that really answers the question. The federal rules of civil procedure, which govern discovery and all procedural issues in federal court litigation, say in Rule 26B1 that private parties are entitled to gain access to all discovery, including documents, that may reasonably lead to the discovery of admissible evidence. That's an incredibly broad standard, probably broader than in any jurisdiction in the world. And what that means is plaintiffs can pretty much get what they want as long as there's some relevance argument and it's not unduly burdensome. So, what does that mean about leniency documents? Can plaintiffs get them? Absolutely. And if their complaints survive the motion to dismiss the defendants inevitably file, they're going to get them. They will get the documents that were submitted to the DOJ. The real question is when, and that's an important question. So, in private litigation, particularly class action cartel litigation, which can go on for years, the merits discovery, that is, the exchange of information between the parties relating to the merits of the plaintiff's claims, may not happen for many months or even many years after the consolidated class action complaint has been filed. Now, the plaintiffs, of course, don't want to wait until merits discovery starts. They want to get those leniency documents now, as soon as possible. Why? Well, just like as Brent said, those documents can provide a roadmap to the DOJ's investigation. They also can provide a roadmap to the plaintiffs for what their case is going to look like. Because often, when these class action complaints are filed, the plaintiff's lawyers don't know much. They may know no more than what's appeared in the press, or if one of the defendants has pled guilty already, what appears in the DOJ's press release and publicly filed documents, and then whatever they can find out by their own investigation. But if they can get their hands on the leniency documents, now they've got something. That's gold to them. So the earlier they get those leniency documents, the stronger their complaint can be. And it also gives them leverage in trying to negotiate early settlements with some of the defendants, which they like to do. Why? It feeds their piggy banks, for one thing. They want some money for all the money they're investing in these cases, but also then their cooperation, and they're going to get even more information. What do the defendants want to do? Delay, 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 delay. We don't want the plaintiffs getting those documents until merits discovery starts, which is why when the DOJ intervenes, like they just did in the capacitor litigation, and asks for a stay, we love those guys. We love the Department of Justice when they do that. So that's one way for delay can occur. What's the other way delay can occur? We do it. The defendant's lawyers, we do what we can to make the plaintiffs wait until merits discovery starts. We often lose because frequently the judge will say, nah, it's leniency documents, it's easy for you to produce, you got them all together in one file, just turn them over. And often, to my surprise, I must say, the lawyers for the defendants don't fight that. But sometimes they do, and sometimes they win. In the air cargo class action litigation, which many of you are familiar with, in which I was involved, representing Cathay Pacific, 53 air carriers around the world were sued in the United States for fixing prices on the rates for cargo shipments. TAM was in there, and Cathay Pacific, and plenty of others. Lufthansa was the amnesty candidate. They got conditional amnesty from the Department of Justice in that case, and then once the class action got rolling, they settled with the plaintiffs. And as part of that settlement, they were required to cooperate, including by turning over their leniency documents. So Lufthansa wanted to give the plaintiffs their leniency documents, A, because they were required to do so under the settlement, and B, because under ACPERA, a U.S. statute that addresses remedies in private litigation, they would get the benefit of detrebling if the DOJ certified that they cooperated sufficiently, meaning they don't have to pay triple damages, they pay single damages. So Lufthansa had a big incentive for the plaintiffs to get the documents, and the plaintiffs had a big incentive. So what did they do? They filed a motion with the district court asking for a protective order. Why? Why they need a protective order? Because the plaintiffs wanted the documents and they didn't want us to get them. They didn't want us to see what the plaintiffs were getting. So I remember we were on a joint defense group call with law firms for the 53 airlines, and someone said, well, what can we do? They always get the leniency documents early. And I thought about it, and I thought, well, I don't know why. It's discovery. They're not allowed to get discovery now. Discovery hasn't started yet. So I wrote up the motion. People looked at it and said, well, it's not bad. and gave me some comments. Anyway, we ended up filing in opposition, not a motion. We opposed the motion filed by plaintiffs in Lufthansa and argued two things. I argued that they're not allowed to get this now. It's discovery. Michael Hausfeld, who was arguing against me, many of you know, he said it's not discovery. I mean, we always get this stuff now. I said, what do you mean it's not discovery? Michael, you wrote right in this paper that the Lufthansa documents are discovery, so you don't get them. And we argued that it would create an uneven playing field between the plaintiffs and defendants, and the judge agreed. The result of that was that the plaintiffs didn't get those documents for, I think it was years, 2 years. Now, we can get very, very different results as well. In the, is it the batteries? I'm having a hard time reading my own PowerPoint here. Oh yeah, yes it was. The lithium batteries litigation, the judge came out a completely different way. The judge in that case ordered the defendants to produce the leniency documents to the plaintiffs even before the plaintiffs had filed their consolidated amended complaint. That's huge for the plaintiffs because now they can take the documents and write their consolidated amended complaint based on that evidence. Very often, the first complaints get dismissed in these cases because the plaintiffs don't have enough facts. Now, they've got plenty of facts, and we'll see what happens, but that's a big help to them. So, bottom line, plaintiffs are going to get the documents. The only question is when. Courts have a lot of discretion to determining when that will be, and they tend to come out all over the map. From my perspective, defendants always ought to fight that and not just assume that the plaintiffs are going to get them early on. So, let's step back for a minute and look at the U.S. system from a vantage point. I would suggest that, all in all, the U.S. system is fairly balanced with respect to those competing interests, encouraging leniency applications and giving plaintiffs the right to recover. Because the plaintiffs are going to get them eventually, but except in very rare circumstances, they're not going to get them at a time that Brent thinks is too early and will interfere with their investigation. Now let's take a very quick look at the EU by contrast. The EU system is still evolving, and there have been some very recent developments. So June 14, 2013, the Pletterer decision came out from the Court of Justice at the EU. And in that decision, the Court of Justice said, you national courts are going to decide what leniency materials the plaintiffs in litigation in your courts are going to get. It's up to you. The second recent development is just 3 days before that, the Commission proposed a new directive and with respect to access to leniency materials. Once that directive is signed into law, the member states are going to have 2 years to enact it and finalize it. What did the directive say? Well, the leniency statements themselves prepared for the Commission and settlement statements provided by those being investigated, private plaintiffs can never get that stuff. It's always exempt. Documents submitted to the courts, the plaintiffs can get them within the discretion of the court, taking into account the balancing of those competing interests. But that can't happen while the investigation is pending. And the directive also discourages wholesale requests. Give us everything that you gave to the EU. It has to be more specific than that. So, if we then take a step back and look at the EU system, I would suggest that that also is a fairly reasonable balance, but it's a different kind of balance. I think overall, when we look at the EU and take into account limited discovery rights and other limitations that exist today on private recovery, I think the EU balance tips somewhat more in favor of protecting the investigation's leniency than it does in private recovery. But again, this is an evolving picture, and that may change. Thank you very much.